Hello. Now we go on to chapter 2 of Indian Evidence Act. What does the chapter 2 say? It is of the relevancy of facts. Of the relevancy of facts. Here we will first start with section 5. Okay? Section 5. What does it read? Evidence may be given of facts in issue and relevant facts. What does section 5 say? Evidence may be given of facts in issue and relevant facts. We have already seen what are facts in issue and what is relevant fact. We already know that, right? So here when we are talking about what does section 5 say? Evidence may be given about facts in issue and relevant facts. See why we say may be given. Law does not compulsorily prescribe giving of evidence. Understand? That means to say if I don't have a certain evidence, court cannot compel me. Court cannot say that no. You give your evidence, only then we can go ahead with the case. Have you heard any judge talk like this? No. They will not ask you for any evidence. But if you provide the evidence, then they will base the case on the evidence provided by you. Otherwise, what will happen? The judge will go on with the evidence which has been provided with the other party. As simple as that. Right? So, it is not compulsory to give evidence, but if we give evidence, it is for our own good. So, it may be given. So, that one thing is evidence may be given, may not be given. For what? Facts in issue and relevant facts. Now, if I have evidence only for facts in issue, I don't have evidence for relevant facts. Say for example, there is a piece of land. We'll take up a civil case for a change so that you will understand that it involves both civil and criminal cases. That's it. I have a piece of land which measures 1 acre. Okay. Now, I am saying that I am the owner of it. A is the owner. Clear? I am saying that I am the owner of the 1 acre land situated in whichever place it is. Okay. So, I give a document which shows that I am the owner. But what does the document show? I am the owner, but only of 50 guntas, cents. Whichever is there in your this thing, you can take it up. This ownership title deed, whatever I have given, shows that I am the owner only for 10, 15 guntas, 50 guntas or cents or whatever it is. Okay, probably or 0.250 acres. Clear? Now, what about the other? I am claiming that I am there for 1 acre. I am showing it for 0.5 acre. That means what? Exactly half acre. I say that I am there for half acre. Okay, the document which I shows that it is only for half acres. Now, the court asks me, you say that you are the owner for 1 acre. Where is the document? I say, I have no document, Your Honor. I have only this document with me. Court cannot say, in that case, you cannot go ahead with the case. No. If the opposite party is able to prove that I am owner only for half acre and not for the 1 acre, then the case will go obviously in his favor. Okay? But I will be able to prove only this much. So, what will the judge base his opinion upon? Only this. Understand? What is the facts in issue? I am the owner, so I want a declaration. This is the fact in issue. I want a declaration to be called as the owner. What is the relevant fact? All the evidences that I produce, documents. Now, I am able to give them RTC. I am able to give them mutation register. Everything is there, but everything shows half acre. Or probably whatever is the bill upon which I am basing the case is not there. Okay, I don't possess it. But what I show, the extract in the mutation register, the extract in the RTC, my tax paid certificate, I am providing everything. But where is the main document of will? I am unable to produce. I say I don't know where it is. Right? So the case may come in my favor, may not come. So what is the relevant fact over here? I am able to prove it but not sufficiently proved. Everything is interrelated to each other. Okay? Now, if there is one more interpretation to this, if I am able to provide evidence only for the facts in issue and not for the relevant facts, even then the judge cannot say anything. He will just go by whatever is the evidence produced. If I am unable to produce evidence for facts in issue, or say relevant facts, better. If I am unable to produce evidence for relevant facts but I am able to produce evidence for facts in issue, the case will go on like that, right? But there should be, as we already know, prima facie evidence. Only when there is prima facie evidence can the case be cognized and it can be taken ahead. Prima facie evidence is very, very important. Clear? Next we go to section 6, which talks about relevancy of facts forming part of same transaction. What does section 6 say? Relevancy of facts forming part of same transaction. Very simple. Actually, only the title is like this. It's very simple. Say for example, we take up some loan. A person has taken a loan of rupees 10 lakhs. How does he agree to give? I will give you 10,000 each every month. Understand? He says, I give you 10,000 rupees every month as a repayment. Plus an interest of 12% per annum or whatever it is. I know this is too high, but I am just quoting it, okay? Now, this is what he says. So, totally the principal plus the interest amount goes to 10,000 rupees. He says both put together I will pay 10,000 rupees. Okay? Now, 10,000, 10,000, 10,000, 10,000, 10,000, 10 times it has to be. This is 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10 times when he pays this, not 10,000, it goes on and on and on, I know it. But still I am just giving you an example of how to do it. All these are part of the same transaction. What's the transaction? 10 lakhs. Okay, suppose he says 1 lakh I will pay you per month, then it will be 10. If it is 10,000, then it will be too long. Am I right? We will take it as 1 lakh. So when it comes to 1 lakh, there are 10 transactions which are here. So which is the main transaction? Loan of rupees 10 lakhs. Part of the same transaction. These are all the parts of the same transaction. So how will it be taken? Jointly and severally. I'll explain. How should it be treated when the case comes before you? How will you treat this case? He says, sir, I took a loan for 10 lakhs. I am paying 1 lakh. How can you treat it as same transaction? No. The entire thing is taken as a single transaction and these are all parts of the same transaction, right? So why? Because it is related to the main transaction. Understand? So what is the fact in issue? Loan of rupees 10 lakh. What are the relevant facts? These are all the relevant facts. But suppose the case is like, sir, he has already paid 4 lakhs. 5 and 6 lakhs he has not paid. 5th and 6th day time, that is the month, he has not paid, your honor. Then what happens? This 5 and 6 becomes the facts in issue. This 10 lakhs, all this 1, 2, 3, 4, 6, 7, 8, 9, 10, not at all in question unless he has already paid. This 5 and 6 become facts in issue. All the others become relevant facts. Simple. Okay? When you say this is the facts in issue, why? Because this is the ones which he has not paid, or probably he has given the check which has got dishonored. Can be anything. So when you do say that, this becomes the facts in issue, rest all becomes the relevant facts. He said he will pay in 10 installments, Your Honor. He paid the first 4 installments. He did not pay, or his check got dishonored for these 2. He is yet to pay all the others. This doesn't matter much, am I right? But still the entire thing becomes a relevant fact. So now how will you do it? How will you treat it? When this is fact in issue, rest all are relevant facts, you have to treat it jointly and severally. When will you treat it jointly? As the one transaction. The entire thing is one transaction. The entire thing is one transaction. Full up to loan is one transaction. Again, when you take the repayment part, that becomes one transaction. Okay? And then this becomes one transaction, this becomes one transaction. So this becomes a part of this. Loan is one part, repayment is also the other part. When you come to repayment, you have so many other parts in between. So you have to see whether the entire repayment, if he says, sir, he has not at all repaid me, then what you should think? Loan is one part, the entire 10 is another part. But if he has taken the loan and he has paid the first 4 but only these 2 he has not paid, then this becomes one part. Rest all becomes the other part. You understand? This is how you should interpret it. So when it comes to that, jointly you will say the entire thing is one part, or this is one part, whatever is the fact of the case. Severally, you have to think of it as individually. You have to deal with it as individually. If he has not repaid the 5th and 6th installment, can you give an order saying that, no, you have to pay the entire 6 lakhs. Can you do that? No. How should you pass an order? For this 5 and 6 only. Therefore, how will you be treating this? Jointly and severally. Clear? We go on to the next section. Section 7. What does section 7 read? It reads as facts which are the occasion, cause or effect of facts in issue. See, all these talk about which are all the relevant facts. What are all the relevant facts? How do you as a judge find out which are the relevant facts? How will you find out which are the relevant facts? That's what we have been reading from section 5 onwards. So from section 5, the entire chapter of chapter 2 tells you what are taken as relevant facts. So right from section 5, these are all deemed to be relevant facts by the judge when you are taking up a case. Understand? That's why we say that. See, when you are reading section 5, that also acts as relevant facts. Section 6 acts as relevant facts. So each section talks about what are all the relevant facts. Clear? So now we go on to section 7, which reads as facts which are the occasion, cause or effect of fact in issue. Occasion, cause or effect of facts in issue. Occasion, you know, happening or not happening, am I right? Anything that happens or not happens. This is a general term. Occasion is something which happens or not happens. So obviously when the occasion is there, you file a case. What should the occasion be? Occasion can either be the cause or it can be the effect. So what is the occasion? It can either be the cause or effect. of what? Of fact and issue. Let me explain. So we'll take the previous example. What is the occasion there? Loan and repayment. Non-repayment or dishonor. Depends upon the case. Whatever case you get, you can write down that particular thing. Okay. Here I am just writing to you generally so that you understand what I am speaking. Here the occasion is loan and non-repayment, both together. Understand? Both together. Understand? So here when I am talking, what is the cause? Loan. What is the effect? Non-repayment or dishonor. Understand? So what is the cause? What is the effect? Loan is the cause. Effect is non-repayment or dishonor. So what will be the facts in issue over here? Facts in issue will be both loan as well as non-repayment or dishonor. Sir, I gave him a loan of 10 lakhs. He did not repay me. Or whatever is the post-dated check that he gave, it got dishonored. Understand? So this is what is the relevant. So what happens? This becomes a relevant fact. This becomes a relevant fact. What is the fact in issue? Both together. When you provide the evidence, you have to provide this also, this also. So both of them, though it is the fact in issue. Fact in issue is what? Non-repayment or dishonor. What is the relevant fact? Loan. If there are any repayments which have been made, then those repayments are also deemed to be relevant facts. He paid for 4 lakhs, he paid 4 lakhs and then he dishonored. Or he did not pay. Then those 4 lakhs become relevant facts. So what does section 7 say? Occasion, cause or effect of facts in issue. Understand? Next we go to the next section. Section 8. Keep in mind, unless I tell you that the sections are specifically for criminal laws, don't deem it to be only for criminal laws. Okay? Evidence Act is common to both civil as well as criminal, unless specified in the Act. Okay? Now section 8 reads as motive, preparation and previous or subsequent conduct. Motive, preparation, previous or subsequent conduct. Okay? Now when we are doing this, what are you seeing? Why is this important? This is very important when it comes to especially criminal cases. Why? Because criminal cases, when you see the IPC, you know what is important over there. Am I right? Mens rea. Criminal intention is what is important in IPC. Now when you are automatically thinking about the intention of the parties, civil cases we don't bother about intention. Am I right? What we focus upon is only the act of the party or the parties. But in criminal cases, we focus on the intention of the party or parties. Clear? So here it is very specifically more often than not used only for criminal cases. What do you have here? Motive, preparation, previous or subsequent conduct. What is motive? The background. What is there in the mind? What is the intention? Right? So this is known as motive. What's the motive? What is the goal? What is the aim? You know, when we put it in positive aspects, motive becomes the inspiration for us to do something positive. Okay? So motive means the intention. It involves the mind. What is preparation? Preparation is physical explain. Okay. See, when there is an intention, obviously there will be a preparation. What sort of preparation will it be? It can be physical and or mental. See, when we are talking about intention, suppose I feel I want to kill that person. I feel like killing that person. Okay? That is an emotion. So, in order to put it into action, what should I do? I should prepare. I should either get a gun or a knife or something like that. Right? Something with which I can kill the person. So that is physical preparation. How should I mentally prepare? Okay, when I reach that spot, I have to do like this, I have to act like this. Mentally prepare myself. See, I am talking, sorry for taking the example, when we are talking about suicide bombers. Okay, they have to mentally as well as physically prepare themselves. Mentally they have to prepare themselves to die, to sacrifice. They can be of any religion. Religion is not a matter. It is only the human mind which matters over there. So they have to mentally keep themselves alive by saying that, yeah, I am ready to sacrifice myself. And then you have the physical preparation, which tells you what all you need, how you will be going, coming, all these things, what you should need to prepare. And then the previous or subsequent conduct. This is very, very important because in certain offences, you have something known as first time offenders, repeat offenders or habitual offenders. Repeat offenders, habitual offenders, right? And then convicts who again commit a crime. There are so many such people, right? So you should know what is the previous or subsequent conduct. See, for example, I will just give you an example. Chapter 12 of IPC, which talks about coins and stamp. If an accused has been arrested and convicted under Chapter 12 of IPC once, and if he commits the same offence a second time, then he is liable for maximum twice the imprisonment term. Maximum, I am not telling you it is compulsory, maximum of twice the imprisonment term. So the imprisonment term will be enhanced, it will not be compounded, it will enhance. Understand? So in such a case, you should know this previous and subsequent conduct. Or you may be knowing of people who are discharged on good behavior. Every Independence Day happens and then you have convicts who are released, right? So when you have Gandhi Jayanti, convicts who are released because they show good behavior, right? So in that case, previous or subsequent conduct. For that also you have to think of previous and subsequent conduct. For commission of commission of an offence also, you should think about the previous or subsequent conduct. There may be people, in a fit of rage, they may kill someone and later surrender to the police saying that, oh, I am sorry I did this. I did it out of fit of anger. Please, plead guilty, right? So in such cases, what will happen? So it can be any type of conduct. Understand? Next, we go to the section 9. Section 9. Facts necessary to explain or introduce relevant facts. Facts necessary to explain or introduce relevant facts. Facts which are necessary to explain or introduce are also relevant facts. Explain or introduce. See, for example, I give a will as prima facie evidence. Okay? And then I say, under the will I am eligible, Your Honor. So in that case, what I have to do? I have to give evidence. In what form? First of all, I have to produce the will. Am I right? I have to produce the will. Apart from that, I have to prove that the signature is true. Signature is true. See, if it is a will, automatically it will come under shall presume. Okay, but signature and then the contents, these have to be proved. The will, when we are saying, shall be presumed because it's a document, compulsory document. So automatically the date, the stamp paper value, all that will be presumed, shall be presumed. But when you are talking about the signature which is there or the contents are there, the court may only presume, it shall presume. If there are objections, then we have to prove that also. Right? So anything which explains. So I have to give an evidence to explain that I am so and so person, I am eligible under the will, nobody else is there. See, if you are filing a P&SC case, probate and succession, this is what we prove, nobody else is there, Your Honor. I am the only one who comes under this will, who is eligible under this will. Right? So then we will have to explain. So that explanation becomes a relevant fact. Same way, introduction becomes a relevant fact. When I am claiming a property, I say, I am my grandfather's daughter's daughter's daughter. Great grandfather, I am sorry. Okay, so when I say that, what happens over there? Then I introduce myself. Then that becomes a relevant fact. So when I am saying, I have a right over the scheduled property, Your Honor, that is the fact in issue. How do I have the right? I introduce myself. I am so and so person, so and so person, so and so person, so and so. Therefore, I have a right in the ancestral property. So that also becomes a relevant fact. When we get onto the witness box, I am sorry, when the clients get onto the witness box, witnesses get onto the witness box, what happens? The judge will tell me your name. So the person tells the name. That doesn't mean that the judge doesn't know, because we have already given list of witnesses. Right? So when he comes on to the judge wants to recognize, judge wants to know who that person is. Therefore, the person has to introduce himself or herself. Then it becomes a relevant fact. So when we are writing, when we are typing PW2 told so and so, so and so, so and so, so and so. Then while referring, we see who is PW2. Then we get the name there. Right? That is how the section 9 works for relevant facts. Thank you.